Good day, everybody. Welcome to another episode of the Entheogenic Esquire YouTube channel. Hope everybody's had a great week this week. Today, we're going to continue jumping into a lot of these court filings that I found in the Tyler Robinson case in the Utah County Court there. Today, in particular, we're going to be looking at a notice filed by the prosecutor, basically notifying everyone that they have an open file policy in regards to their evidence and all the stuff in their files. An invitation for the defense to schedule an appointment to come and hang out with them to check out the evidence. So before I do my analysis, let's jump on in and take a look at the actual document here. So as you can see, this was filed by the Utah County Attorney. It looks like Jeff Gray. Obviously a Tyler James Robinson case. So the title here is Notice of State's Open File Policy and Invitation to Review Case File and Inspect Physical Evidence. So let's just run through the language real quick, and then we'll do a trial lawyer's analysis of this. So right here at the first, we see that this is the state by and through Chad. Okay, so it's actually Chad that filed this. Okay, so Chad makes this filing, which is a notice pursuant to, and notice this isn't pursuant to any rule, and we'll talk about this in a minute, but there's no rule or Code of Criminal Procedure. It's literally just invoking their open file policy, and hereby invites counsel for defendant to review the prosecution's case file with the exception of work product. So just so y'all know, work product would be anything the attorney has personally created, so whether it be notes, drafts of motions, things of that nature, but items in which the lawyers themselves have created them is what they're referring to as work product, and this is very standard that would not be included in any kind of discovery policy or invitation to review a file. It says here they also invite the state to, or the defense to, inspect all physical evidence seized by law enforcement. Hey, except the evidence that was, paved over, right? And just so we know, we saw those videos the other day. The state was in custody of control of that area. I mean, they own the property, but still, they had it cordoned off and everything. So, no, we're not going to be able to inspect all the physical evidence that y'all have had in your possession, but hey, I guess the thought's what counts, right? And then here we see, and this is kind of nonsensical, it says, counsel of record may by appointment come to our offices to review a file. Now listen to this. In fact, we urge you to make such an appointment prior to any case going to trial so that we can ensure we have provided you with all available information received by this office. So it's, well, of course we'd want to do it before we go to trial. I mean, yes, why would we not schedule an appointment before trial? And moreover, why would we schedule an appointment after trial? It just makes no sense. And then here we see it goes, our evidence custodian agrees to make physical evidence in their custody available by appointment for your review and inspection. And then here, and this is the last page, it says the evidence custodian or an officer to remain present during the inspections to ensure chain of custody. So it's just someone's going to be present there to watch the inspection, just so that way they can ensure what's called chain of custody. And it's usually a form that's filled out every time someone touches a piece of evidence or takes custody of it. They fill out a form, so that way whenever it goes to trial, they can authenticate it and basically ensure that it is the item that's claimed to be, and that people can attest to that it hasn't been altered or modified in some way. So that's what chain of custody is important for. So let's transition back over here and let's do a little bit of analysis with this. Okay, so this was filed on October 27th, 2025. So it would have been more than a month after they paved over the crime scene. As I stated when we were looking at it, this is not pursuant to any rule of criminal procedure. It's literally just them announcing their policy into the court record. I've never seen this occur. I don't know how normal it is. Now, I haven't done the most criminal cases ever, but I've never seen this before. So we have to ask, so what was the strategic purpose here? Well, I obviously think that one of the strategic purposes was for optics, essentially, to try to make them look a little bit better and more transparent and open to discovery after they had a little bit more than a month prior straight up covered up and paved over a crime scene. So I think it's a little bit of damage control is a little bit behind this. with that to preempt any future discovery disputes, right? So if there comes a time when the defense is like, hey, judge, they're not being upfront with the evidence, they're not letting us see everything, which, hey, I think paving over the crime scene pretty much, fits that description. But in the future, if there's a discovery dispute, they'll be able to say, well, judge, we have an open file policy and we're so transparent, we announced it. They can make an appointment, but they better do it for trial. So again, I think this is just optics and trying to position themselves in the future for what they probably suspected will be a motion for an adverse inference for paving over the crime scene. I hope we see that. And again, reframing the narrative, right? So that goes along with the optics, just trying to reframe the narrative that's obviously been built around the fact that they paved over the crime scene. So this does not cure, so I want to make everyone aware, this does not cure any defect or potential liability for them paving over the crime scene. And yeah, this was, and I made this point, but let me just make it one more time. This was filed very early on, but yet still about a month after paving over the crime scene. So it seems this was probably due to optics. Again, I've never seen this. I don't think that it's very common, but I can for sure be corrected. Filing notices like this. And then Erica Kirk wants to file the notice for a speedy trial, wants to hurry things up. Yet the way this reads, the defense is going to be at the mercy of the prosecution's schedule, essentially. They're having to schedule an appointment. So what is this? Trying to prod them to hurry them up and then through this policy delay them through pushing appointments back? I mean, I don't know that's the strategy here. This is just my opinion. But it seems like this is all just a big optics PR campaign, essentially, to try to hurry the trial, obfuscate the fact that they paved over the crime scene, and at the same time try to look like they're the most transparent prosecutor's office in history. And yeah, so this is interesting. That's about all I have on this for right now. It obviously fits within some other stories and narratives that we're discussing, so it will be brought back up. But what are your thoughts on this? Is this just a ruse, just trying to do damage control? That's what it looks like to me, in my opinion. I'd love to hear your thoughts. Hope y'all, if I don't hear from you before, hope y'all have a great weekend. Much love.